The point of order has been withdrawn. Is Ms. Weiner on the floor of the House? The following amendment, the clerk read the amendment.
Amendment by Zwiener.
The chair recognizes Ms. Weiner to explain the amendment.
Mr. Speaker, members, this is a simple amendment that is here to try and guarantee that our cities and counties can continue to regulate the right-of-ways that they own. This is important because this bill provides field preemption for the Natural Resources Code, which includes regulation of pipelines. When a pipeline comes through a city, it has to pass underneath roads. Right now, cities have tools to determine the depth of that pipeline so that they can work with the company and make sure that the pipeline is safe and doesn't interfere with their existing infrastructure, both the road itself as well as any other utilities. This is a critical thing to keep our communities functional and operative. I don't know how many of y'all have had a large pipeline with eminent domain authority come through your district, but they're hard folks to negotiate with. When a pipeline came through Hays County in 2018, they did not even know they were crossing through the city of Kyle because they were working off 5-year-old maps. With those 5-year-old maps, they had no clue that they were interfering with existing city of Kyle right-of-way and both existing roads and planned roads. The city of Kyle had to reach out to them directly and do this negotiation in order to not interfere with the quality of life for their residents. The city of Kyle did that aggressively, worked with the company, but made sure that that pipeline didn't interfere with the local roadways. Members, under this bill right now, those same officials who negotiated that space, who worked to try and keep the pipeline from interfering with their roads, their power lines, their water lines, would risk being sued by the company. And not just sued as a city, but sued as individuals. So let's make sure that those city officials who are doing everything they can to try and protect their local infrastructure in the ground know that they still have the authority to do so and can't be bullied out of it by threats of frivolous lawsuits. Members, I ask for your favorable consideration.
The chair recognizes Mr. Burrows in opposition to the amendment.
Thank you, Mr. Speaker. Members, this is a completely unnecessary amendment. I oppose.
The chair recognizes Ms. Weiner to close on the amendment.
Members, this amendment is necessary. This bill is so broad, none of us in this room have a full scope of what operations of our cities and counties it is going to affect. So if some of these amendments, if the author of the bill believes some of these amendments are duplicative of what is in existing code, let's go ahead and duplicate it. Let's make sure that our cities and our counties can continue with core services like roadways, water, electricity, like they are doing right now. This bill, as written, would make it hard if a pipeline came through your city for your city to negotiate with the pipeline company on exactly where it went and how deep it went under their existing city infrastructure. If you want that, vote no on this amendment. If you want common sense and to make sure that your cities can operate their core functions, vote yes.
Ms. Weiner sends an amendment. The amendment is not acceptable to the author. There's a record vote requested by Mr. Wu. The clerk will ring the bell. Show Mr. Burrows voting nay, Ms. Weiner voting aye. Have all members voted? There being 57 ayes and 89 nays, the amendment fails to adopt. The following amendment, the clerk read the amendment.
Amendment by Temish.
The chair recognizes Ms. Themish to explain the amendment.
Thank you, Mr. Speaker. Members, my amendment adds language to Section 15 of the bill, which covers the occupational code, to regulate a massage establishment in accordance with Section 455.005. This amendment is acceptable to the author, and I move adoption.
Ms. Themish is an amendment. It is acceptable to the author. Mr. Wu has requested a record vote. The clerk will ring the bell. Show Mr. Burrows voting aye. Ms. Themish voting aye. Have all members voted? Mr. Burrows voting aye. Have all members voted? Ms. Themish voting aye. There being 123 ayes and 17 nays, the amendment is adopted. The following amendment, the clerk read the amendment.
Amendment by Anchia.
The chair recognizes Mr. Anchia to explain the amendment.
Thank you, Mr. Speaker and members. I know we've fallen into a little bit of a pattern of votes this afternoon. And it reminds me of my first freshman session when a senior member pulled me aside and he said, listen, you are your votes. You are the votes that you take, what you put your name next to. And in Dallas, like many other places, I just want us to bear that in mind, we have non-discrimination ordinances. And I do believe that the author of this bill, in good faith, believes his bill does not impact non-discrimination ordinances. And we've been having this conversation since this bill went through committee. I sit on State Affairs and we had this dialogue. And I think he has a sincere belief that it will not touch non-discrimination ordinances. However, I also have lawyers who are concerned that non-discrimination ordinances will be adversely impacted. And I think it is the subject of genuine debate on whether or not certain protected classes would be covered by a non-discrimination ordinance locally, yet not by federal law. And so we've been talking over the last few days, and certainly here on the floor, about how we wanted to approach this. My amendment is very simple. If, in fact, this bill does not impact non-discrimination ordinances like the ones we have in Dallas and around the state, then we just need to say so explicitly in the bill so there is no confusion. Why? Because this bill also allows for the filing of lawsuits to challenge ordinances if there is ambiguity. And that's a risk, I will tell you, that I do not want to expose my constituents to. In Dallas, we have non-discrimination ordinances that protect people in housing from discrimination against or discrimination on the basis of gender identity or sexual orientation. There is no case in the state of Texas that is directly on point that says the Fair Housing Act will protect these constituents. They're your constituents, they're my constituents in Dallas, and all around the state where these ordinances exist. And so to avoid any doubt whatsoever, we can simply say in this bill that this does not touch non-discrimination ordinances at all, explicitly. And if you look at the amendment itself, it says it in 3 places. It says On page 2, immediately after line 27, this section does not apply to an ordinance, an order, or a rule that prohibits discrimination. It says it again on page 6. This section does not apply to an ordinance, an order, or rule that prohibits discrimination. And finally, on page 8, it would say that this section does not apply to an ordinance, an order, or rule that prohibits discrimination. Now, they're anti-discrimination ordinances of all types in the state of Texas. Some protect veterans. Some protect the disabled. Others protect on the basis of gender identity or being LGBT. And I think these are really important, and I think the author does too. In fact, during a dialogue during State Affairs, the head of the Texas Association of Business said, no, absolutely. We think these non-discrimination ordinances are important. They set the right business tone for our state, and we don't want those affected either. All this does is say, yes, we agree with you, Mr. Chairman, the author of this bill, but let's make it explicit to avoid any doubt, to avoid costly litigation, and to really give our constituents the comfort that they need, that those protections at the local level will not be called into question, not be stripped away, and not be violative, ultimately, of their rights. So members, I'm grateful for your attention. Thank you for those of you who are listening. I know that there is a legitimate disagreement about the extent to which this bill affects NDOs. I acknowledge it. I think it is healthy, and I just want to avoid doubt with this amendment. So members, as I ask you to ponder that we are our votes, right? We are the votes that we take. All this bill says is I do not want discrimination in this state, and I support local communities that have an ordinance saying no discrimination.
Mr. Speaker,
Ms. Niabi Crowder, for what purpose?
does the gentleman yield?
The gentleman yield for questions.
I do.
The gentleman yield for questions.
Thank you, Mr. Speaker, and thank you, Representative. We know that there are many local cities throughout the state that have passed these local policies that provide protections against employment discrimination on the basis of a variety of protected classes, and some have expanded non-discrimination protections to apply to veterans, immigrants, and other groups that are not always protected by state and federal law. Would your amendment ensure that municipalities can apply non-discrimination protections to groups of people not always covered by state and federal law?
I take the author at his word that he believes his bill does not touch them. There are people who I also take at their word that believe this bill puts at risk non-discrimination ordinances. I say we eliminate that doubt by being express in our intention and saying we will not affect non-discrimination ordinances of any type, and this bill shall exempt them.
And there has also been lots of progress made, and we still have a long way to go regarding protecting employees from discrimination on the basis of their sexual orientation and gender identity. And so as we want to protect LGBTQ workers, we know that the Supreme Court, in fact, has ruled in the Bostock case that Title VII fully protects LGBTQ employees from discrimination, but Title VII only covers a fraction of the state's workforce because it applies to businesses that have 15 or more employees. Would your amendment allow municipalities to expand in non-discrimination protections to LGBTQ Texans?
Yeah, certainly, it would. If a local community wants to respond to those concerns of their citizenry, they'd be permitted to do so expressly if my amendment is adopted.
Okay, and would your amendment also ensure that cities and counties can attract the best businesses, workers, and talent, and ensure that our state is not known as a place where discrimination is allowed to thrive?
So this is what I worry about. I worry about this bill passing and then a bunch of lawsuits seeking to upend non-discrimination ordinances in cities occurring in the absence of federal protection on, as you correctly pointed out, in the workplace, for companies of under 15 employees. As you point out, in housing, If the Fair Housing Act, for some reason, does not apply in Texas, or a Texas state or federal judge says that it does not apply, right, to orientation or identity, then my constituents, your constituents, are at risk. And that's really what I want to avoid. Let's take this risk right off the table, and let's, if we adopt this amendment, it is simply in accordance with the opinion of the author. And I do believe him when he says, I don't think this upends non-discrimination ordinances. Well, if that's the case, let's just be explicit and clear.
Okay, and there are also some cities, some counties have local human rights commissions that they investigate complaints of discrimination. Sometimes that's far, less expensive and quicker than going to court or to file a complaint. Do you think that local human rights commissions should be able to enforce non-discrimination rules without being impeded or impacted by this bill?
I think in this case, our city council members in Dallas are closest to the people, right? And if they wanted to set up a human rights commission to investigate any human rights abuses, I think it's their prerogative. I think they are much closer to the people than politicians in Austin, in fact. They get called, if something goes wrong in community, they get called first, right? And so I think we should, in fact, defer to them. And just let me underscore one more thing, Representative or Chairwoman Nave, which bears mentioning. This is not some sort of cavalier concern that we have. This is not pretext for something else. This is articulating real fear from the constituents that I represent about their ability to be discriminated against on the basis of their orientation or identity in housing and in the workplace. These are real fears, and they feel protected by the city of Dallas's ordinances on the subject. It gives them a layer of protection and confidence and the ability to pursue happiness, right?
And there's an economic impact to that too, right? You're aware of the Texas economist Dr. Ray Perryman's study on the cost to the state for not having comprehensive non-discrimination protections in place?
Look, if we don't have them in place, I fear that we're going to send the wrong signal to the marketplace and to employees. Thank you.
Thank you.
The chair recognizes Mr. Burrs in opposition to the amendment.
Yeah, and members, I'm going to speak a little bit more about this just to make sure that everyone understands. For several weeks now, I have claimed that this does not affect non-discrimination ordinances of all classes, and had some legal briefings. I've shared them with my colleagues and have been under that impression this entire time. In fairness, Representative Anchia, you did bring to my attention there may be some contravening opinion, but of course it was today during the middle of debate, so I've not had a chance to look at it and read it. But up until today, it has been my belief, and confirmed multiple different times, this would not affect NDOs, and I have represented that. And I'm going to stand by and oppose it only because that has been the belief I've had for so many days and by so many people. But, I will read your brief when I actually get a chance to do that.
Mr. Anchia, for a purpose.
Will the gentleman
yield for questions?
Of course.
Mr. Chairman, I appreciate you doing that. I am grateful. This information has been sort of widely disseminated and placed at least in front of your staff for some time now. I apologize that we didn't get to talk about it before the day started, but it is a legitimate concern. And I take you at your word, right? I am not suggesting you're trying to mislead anybody. No. that you've looked at briefing that makes you confident that NDOs will not be touched. I worry, however, that the breadth of your bill really does put in jeopardy, potentially, non-discrimination ordinances. And there is briefing to suggest, if you permit me, there is briefing to suggest the opposite. That in fact, in the absence of on-point case law, it would be very easy for the Fair Housing Act, for example, to be determined not to apply to orientation or identity in Texas, if that occurred. And non-discrimination ordinances would fill that gap. Right, so it's like we're pulling I fear that we're pulling out that safety net as we're engaging in this trapeze exercise. And if we were just explicit about it, then we could, for the avoidance of doubt, just put this to bed.
So the issue being, when you have, a several days down here, which is kind of like months, and you have many conversations confirming, that this is actually not affecting NDOs, it's very hard during the middle of, the debate, and it is the first time I've been made aware that there's an alternative opinion out there that somehow this does affect them, and I just don't think I can pivot on that dime at this point in time, because there has been several confirmation issues where many people from all sides, not just people who want to confirm that, from all sides seem to agree with my analysis and have agreed with my analysis that it does not protect, and believe that. And so I believe that.
And so what do we do? You heard the dialogue between both Representative Nave and me, and me, that in fact, for non-discrimination in the workplace, even though there's a federal court opinion, that it does not impact employers under 15 persons. However, a non-discrimination ordinance in Dallas, by way of example, would protect them.
Well, in employment, we've actually given the rights to the city, which are preserved in here, and that's actually in the labor code. So that's actually explicit in the labor code that they can still do on the employment. So I'm convinced of that. I mean, I don't think there's anything on employment practices that those NDOs are not going to remain valid because of the explicit authority that's given there. I have not briefed the Fair Housing Act, but I thought everybody had kind of come to that consensus. But I'll also make this point. There were several also bill authors who talked about actually getting rid of all NDOs explicitly in my bill. And so I thought the compromise was just not to deal with them in my bill. Rather than making it explicitly clear or getting rid of them, this would be the way to basically try to balance the interest and not make my bill about NDOs. And I still don't think my bill is about NDOs.
Okay, so just so we have clear intent, it is not your intent that this bill affect any NDO at all in the state?
Not only is not my intent, I'm fairly confident that it does not.
If in fact the breadth of the bill is such that we are wrong, and I'm glad you clarified employment, but let's say in housing, the Fair Housing Act is ruled as not applying to the state of Texas, what is our remedy? What do we do at that point to satisfy your intent?
Well, I mean, obviously, we're now dealing with hypotheticals, and I mean, I love playing the hypothetical game, but I don't think at this point in time that it is in jeopardy.
So let me ask you this, because the problem in not wanting to deal in hypotheticals is the minute we put this law out into the world, every fact pattern is a hypothetical, right? And my constituents who are protected by non-discrimination ordinances have to live with the consequences of that. So that's why I'm bringing this amendment, just because everything is a hypothetical, and every fact pattern becomes a hypothetical.
Well, Representative, I've spoken more about this amendment on purpose to make sure the body is aware of it. Yeah. I am going to vote no and oppose it, but if there's members who agree with you, that is with them. But I mean, that is where I am for those reasons, but I certainly understand it.
Thank you, Mr. Speaker.
Mr. Chair, for purpose.
Can we have the legislative intent articulated by the author reduced to writing and placed in the journal?
Members heard the motion's objection. Chair hears none, so ordered. The chair recognizes Mr. Nchia to close on his amendment.
Thank you, Mr. Speaker. Members, I'm grateful for the bill author very clearly stating his intent. Legislative intent is very helpful, any of us who have gone to law school, but it's certainly not dispositive, right? And the reason I think it's very important for us to be explicit in this amendment, think about the non-discrimination ordinances that may be adopted in any of the cities that you represent. Think about the people that they protect. Think about the people that they give hope to. Think about the people who they inspire and who have advocated for them before their local city councils, the people who are closest, the representatives that are closest to the people. And think about whether or not we want to preserve those ordinances. And so, members, I ask you to just look in your heart. We can be explicit here in this bill to make sure there is no confusion whatsoever, and articulate for the state of Texas where our values are. Thank you.
Mr. Anchia sends an amendment. It is not acceptable to the author. A record vote has been requested by Mr. Wu. The clerk will ring the bell. Show Mr. Anchia voting aye, Mr. Burrs voting nay, Mr. Goldman voting nay, Ms. Troxclair voting nay. All members voted. All members voted. There being 61 ayes and 86 nays, the amendment fails to adopt. Any members who wish to speak for, against, or on the bill? The chair recognizes Mr. Turner to speak in opposition to the bill.
Thank you, Mr. Speaker. Members, this bill has been well debated by so many members today, and I'm appreciative so many members brought amendments to try to improve this bill this afternoon. So I think everyone's very clear on what this bill does and doesn't do. I would just say this, that if you believe in your heart of hearts that a one-size-fits-all cookie-cutter policy that emanates in this building is the best thing for your community in virtually every situation, then you should absolutely vote for this bill. If you think that your community has the exact same challenges, the exact same needs, and the exact same lived experiences as another community, a county away, 2 counties away, 200 miles away, 800 miles away, then you should vote for this bill. But if you think that your community has something about it that makes it unique, that makes it special, that makes it such that local elected leaders, your county officials, your city officials, the people that your neighbors who have elected to represent and lead your local communities, if you think that maybe they have something to offer because they have some insights about what's happening in their neighborhoods, in their towns, in their cities and counties, if you think that they bring some value to the process because they have that local perspective that maybe despite our best efforts we may not always have here in the House of Representatives or here in the Texas legislature, if you think maybe they bring some value to that process and bring some local perspective that helps improve your community, as I know my local officials improve my community each and every day, then you should vote no on this bill.
The chair recognizes Mr. Burrows to close on the bill.
Thank you, Mr. Speaker. Members, I just want to sincerely thank all of you for this time, for the debate, discussion. Even those who are opposing this, I appreciate the debate on this, so thank you, and I move passage.
The question occurs on passing the engrossment of HB 2127. A record vote has been requested by Mr. Turner. The clerk will ring the bell. Mr. Burrows voting aye, Mr. Goldman voting aye, Mr. King of Hemphill voting aye, Mr. Harris voting aye of Anderson. Dr. Anderson voting aye. All members voted. There be 92 ayes and 55 nays. HB 2127 is passed in engrossment. The chair lays out on second reading HJR 45. The clerk will read the resolution.
HJR 45 by Shaheen, proposing a constitutional amendment authorizing a local option exemption from ad valorem taxation by a county of a portion of the value of the resident's homestead of a physician who provides health care services for which the physician agrees not to seek payment from any source, including the Medicaid program or otherwise from the state or the federal government, to county residents who are indigent or Medicaid recipients.
The chair recognizes Mr. Shaheen to explain the resolution.
Thank you, Mr. Speaker. Members, I have a local control bill for you. HJR 45 seeks to improve access to health care for the needy and reduce health care costs here in Texas. Our state's existing health care programs for the needy are growing more costly while the choice of doctors is declining. Choice is declining because physicians are incredibly frustrated over the complexity of Medicaid and their cost to administer. As a result, 70% of Texas physicians do not accept new Medicaid patients. That number used to be around 30% 20 years ago. So HJR 45 is a tool to help bring doctors back into the indigent health care program. HJR 45 allows counties to reduce the property taxes of a physician if the physician agrees to provide health care for free to the indigent. The physician must not seek any reimbursement from federal or state programs. This is purely an option for counties. It's permissive and flexible. The process agreement for care and medical services would be decided between the medical professional and each county. Mr. Speaker, I move passage.
The question occurs on adoption of H.R. 45. This is a record vote required by the Constitution. The clerk will ring the bell. Show Mr. Shaheen voting aye. Have all members voted? Ms. Wiener voting nay. Have all members voted? There being 115 ayes and 30 nays, H.R. 45 is adopted.
Mr. Speaker.
Mr. Doorkeeper.
Mr. Speaker, I have a messenger from the Senate at the door of the
Admit the
House.
messenger.
Mr. Speaker.
The chair lays out on second reading HB 3050. The clerk will read the bill.
HB 3050 by Bonin relating to the creation of the Texas State Buildings Preservation Endowment Fund.
The chair recognizes Dr. Bonin for a motion.
Thank you, Mr. Speaker. I move to postpone further consideration of HB 3050 until 9 a.m. Wednesday, April 26.
Members heard the motion. Objecting. The chair hears none, so ordered. The chair lays out on second reading HB 1646. The clerk will read the bill.
HB 1646 by King of Uvalde relating to the use of water withdrawn from the Edwards Aquifer.
The chair recognizes Mr. King of Uvalde to explain the bill.
Thank you, Mr. Speaker and members. House Bill 1646 was brought to me by the Edwards Aquifer Authority. When it was created in the early 90s, the rules were that they could not use any Edwards water outside the boundaries of the aquifer. Turns out that there was a handful of CCNs that went outside the boundaries of the aquifer just a tiny bit. It's never been an issue, but there's a question about whether or not those CCNs can legally provide water in that little area outside the boundaries of the aquifer. This bill simply says that if you had a CCN that was in place at the creation of the aquifer in 1995, then you are able to provide water to that. I move passage.
Does any member speak for or against on the bill? Seeing none, the question occurs to pass on engrossment with HB 1646. All in favor say aye. Opposed say nay. The ayes have it. HB 1646 passed on engrossment. The chair lays out on second reading HB 1255. The clerk will read the bill.
HB 1255 by Smithy relating to limitation periods and arbitration proceedings.
The chair recognizes Mr. Smithy to explain the bill.
Thank you, Mr. Speaker and members. This bill would just clarify that the same statute of limitations that applies to the underlying claim would apply whether the claim is made in a lawsuit or in arbitration. I'd move passage.
Any member speak for or against on the bill? Seeing none, the question occurs on passage of engrossment HB 1255. All in favor say aye. Opposed say nay. The ayes have it. HB 1255 is passed in engrossment. The chair lays out on second reading HB 1704. The clerk will read the bill.
HB 1704 by Wally relating to the establishment of the Workforce Housing Capital Investment Fund program to fund the development of workforce housing in the state, authorizing a fee.
The chair recognizes Mr. Wally to explain the bill.
Thank you, Mr. Speaker. Members, HB 1704 creates a revolving loan fund through a one-time $50 million capital investment to both help home ownership activities in the state of Texas, but also to support workforce training for skilled trades. The proposal would also The proposal will also have a component to train skilled construction trade labor, working with our Association of Builders and our Apartment Association and our local community colleges. HB 1704 helps Texans on a path towards home ownership and a major step in achieving wealth equity, social mobility, and progress. I move passage, Ms. T.
Does any member wish to speak for or against on the bill? Seeing none, the question occurs on passage and engrossment HB 1704. A record vote has been requested by Mr. Schlatzline. The clerk ring the bell. Show Mr. Wally voting aye. Have all members voted? There being 92 ayes and 53 nays, HB 1704 is passed in engrossment. The chair lays out on second reading HB 1159. The clerk read the bill.
HB 1159 by Anderson relating to county and municipal housing authority pet policies.
The chair recognizes Dr. Anderson for a motion.
Thank you, Mr. Speaker. Members, I move to postpone further consideration of HB 1159 until 11 a.m. Monday, April 24th.
Members heard the motion. Objection. Chair hears none, so ordered. The chair lays out on second reading HB 821. The clerk read the bill.
HB 821 by King of Hemphill relating to the placement of electric vehicle charging equipment on state property.
The chair recognizes Mr. King of Hemphill to explain the bill.
Thank you, Mr. Speaker. House Bill 821 would simply allow state agencies to partner with private business to place EV charging stations on state property, such as state parks. Move passage.
The question occurs on passage of HB 821. The record of vote has been requested by Ms. Isaac. The clerk ring the bell. Mr. King of Hemphill voting aye. Have all members voted? There have been 112 ayes and 36 nays. HB 821 is passed in engrossment. The chair lays out on second reading HB 3478. The clerk will read the bill.
HB 3478 by King of Uvalde relating to mediation of certain fee disputes between towing companies and motor campers.
The chair recognizes Mr. King of Uvalde to explain the bill.
Thank you, Mr. Speaker. Members, House Bill 3478 has to do with tow trucks and motor carriers, large 18-wheeler companies. The bill says that if a motor carrier is dissatisfied with a bill that's over $20,000, that they can request mediation rather than having to sue the tow truck company. It is supported by one of the tow truck companies and the motor carriers. I move passage.
The question occurs on passage of engrossment HB 3478. All in favor say aye. Opposed say nay. The ayes have it. HB 3478 is passed in engrossment. The chair lays out on second reading HB 1922. The clerk will read the bill.
HB 1922 by Dutton relating to periodic reauthorization of municipal building permit fees.
The chair recognizes Mr. Dutton to explain the bill.
Thank you, Mr. Speaker and members. House Bill 1922 simply authorizes and reauthorizes building permit fees to be established and reauthorized after 10 years. And I move passage. Thank you.
The question occurs on passage of engrossment HB 1922. A record of vote has been requested by Mr. Kane. The clerk will ring the bell. Show Mr. Dutton voting aye. Mr. Harless voting aye. Have all members voted? There have been 145 ayes and 0 nays. HB 1922 is passed in engrossment. The chair lays out on second reading HB 1925. The clerk will read the bill.
HB 1925 by Harless relating to the continuation and operations of a healthcare provider participation program by the Harris County Hospital District.
The chair recognizes Mr. Harless to explain the bill.
Thank you, Mr. Speaker. Members, House Bill 1925 is a renewal bill for the Harris Local Provider Participation Fund. This bill simply changes the sunset date and extends it for 2 years. I move passage.
The question occurs on passage of engrossment HB 1925. All in favor say aye. Opposed say nay. The ayes have it. HB 1925 is passed in engrossment. The chair lays out on second reading HB 2556. The clerk will read the bill.
HB 2556 by Oliverson relating to the licensing and regulation of physician graduates and the authority of an insured to select a physician graduate under the insured's health insurance policy, requiring an occupational license, authorizing fees.
The chair recognizes Dr. Oliverson to explain the bill.
Thank you, Mr. Speaker. This House Bill 2556 will create a new kind of medical license, which will allow medical graduates that haven't placed in a residency program, as well as certain doctors from an approved list of countries other than the United States, to practice under a limited medical license, thus massively expanding the pool of healthcare providers. Move passage.
Any member speak for or against on the bill? Seeing none, the question occurs on passive engrossment. HB 2556. All in favor say aye. Opposed say nay. The ayes have it. HB 2556 is passed in engrossment. The chair lays out on second reading HB 2802. The clerk will read the bill.
HB 2802 by Rose relating to the Medicaid application form and communication with Medicaid recipients.
The chair recognizes Ms. Rose to explain the bill.
Thank you, Mr. Speaker. House Bill 2802 enables Medicaid managed care organizations to text beneficiaries important health care and renewal information on an opt-out basis. Move passage.
Any member speak for or against on the bill? Seeing none, the question occurs on passive engrossment. Is 2802. All in favor say aye. Opposed say nay. The ayes have it. HB 2802 is passed in engrossment. The chair lays out on second reading HB 2016. The clerk will read the bill.
HB 2016 by Hernandez relating to the eligibility requirements for a license as a massage establishment, massage school, massage therapist, or massage therapy instructor.
The chair recognizes Ms. Hernandez to explain the bill.
Thank you, Mr. Speaker and members. House Bill 2016 would make a person ineligible for obtaining licensure as a massage establishment, massage school, massage therapist, or massage therapy instructor if they have been convicted, pled guilty, or received deferred adjudication for sexual assault or aggravated sexual assault. I move passage.
Any member speak for or against on the bill? Seeing none, this question occurs on passive engrossment. HB 2016. All in favor say aye. Opposed say nay. The ayes have it. HB 2016 passed in engrossment. The chair lays out on second reading HB 1114. The clerk will read the bill.
HB 1114 by Cassell relating to the service area of the Blinn Junior College District.
The chair recognizes Mr. Cassell for a motion.
Thank you, Mr. Speaker. Members, I move to postpone further consideration of, I know Mr. Schofield is a true gentleman, 11:14 until 10 a.m., Wednesday, April 19th.
Members heard the motion. Is objection? Chair hears none, so ordered. The chair lays out on second reading HB 1589. The clerk will read the bill.
HB 1589 by Cook relating to increasing the criminal penalty for certain family violence assaults.
The chair recognizes Mr. Cook to explain the bill.
Thank you, Mr. Speaker. Members, House Bill 1589 simply gives prosecutors an opportunity to enhance a violation of a protective order to a third-degree felony. Move passage.
Any member speak for or against on the bill? Seeing none, this question occurs on passive engrossment. HB 1589. All in favor say aye. Opposed say nay. The ayes have it. HB 1589 is passed in engrossment. The chair lays out on second reading HB 1737. The clerk will read the bill.
HB 1737 by Leach relating to automatic orders of non-disclosure of criminal history record information for certain misdemeanor defendants following successful completion of a period of deferred adjudication community supervision.
The chair recognizes Mr. Leach to explain the bill.
Thank you, Mr. Speaker. Members, this is our clean slate legislation. I do have an amendment.
The following amendment, the clerk will read the amendment.
Amendment by Leach.
The chair recognizes Mr. Leach to explain the amendment.
Thank you, Mr. Speaker. Members, this is our amendment to the clean slate legislation. Move adoption.
Mr. Leach does have an amendment. It is acceptable to the author's objection to the adoption of the amendment. Chair hears none. The amendment is adopted. The chair recognizes Mr. Leach to close on the bill.
Move passage.
The question occurs on passing the engrossment of HB 1737. All in favor say aye. Opposed say nay. The ayes have it. HB 1737 passed in engrossment. The chair lays out on second reading HB 598. The clerk will read the bill.
HB 598 by Shaheen relating to creating the criminal offense of possession of an animal by a person who has previously been convicted of an offense involving animal cruelty.
The chair recognizes Mr. Shaheen to explain the bill.
Thank you, Mr. Speaker. Members, House Bill 598 establishes a Class C misdemeanor for a person who has been previously convicted of an offense involving animal cruelty and is found in possession of an animal, again, within the last 5 years. Certain offenses include an attack on a subsistence animal, cruelty to a non-livestock animal, dog fighting, and cockfighting. The bill was unanimously voted out of committee. Mr. Speaker, I move passage.
The question occurs on passing the engrossment of HB 598. All in favor say aye. Opposed say nay. The ayes have it. HB 598 is passed in engrossment. The chair lays out on second reading HB 596. The clerk will read the bill.
HB 596 by Shaheen relating to a local option exemption from ad valorem taxation by a county of a portion of the sale of the value of the resident's homestead of a physician who provides healthcare services for which the physician agrees not to seek payment from any source, including the Medicaid program or otherwise from the state or the federal government, to county residents who are indigent or are Medicaid recipients.
The chair recognizes Mr. Shaheen to explain the bill.
Thank you, Mr. Speaker. House Bill 596 allows counties to reduce the property taxes for a physician who provide health care for free to the indigent. These physicians may not seek any reimbursement for federal or state programs.
Ms. Thompson, for what purpose?
Would the gentleman yield?
Would the gentleman yield for questions?
I'd be happy to.
The gentleman yields.
Mr. Shaheen, there are other areas where people can contribute to the contribution of the community in different capacities. Would your with your amendment on House Bill 596 be accommodating to those persons who will be contributing to the community for ad valorem taxing deductions?
I'm sorry, man. It was hard to hear you. Can you repeat the last part?
Well, there are other areas that persons can contribute in society for the position of helping people in rural areas in the capacity of health care.
Yeah.
Would you be amenable to including those persons within your bill?
No persons within what?
Pardon me?
Would I be amenable to what? I can't hear you.
Would you be amenable to adding them to your bill as well?
Adding who?
Let me come down and speak against your bill.
Okay.
Mr. Speaker. Mr. Canales, for what purpose?
The gentleman yield.
Would the gentleman yield for questions?
Sure.
The gentleman yields for questions.
So I'm going to kind of follow up on what Chairwoman Thompson was asking, that there are many members of the community that help indigent people, and are you open to giving everybody a 50% tax reduction on their property?
No, so this is part of the county indigent health care program. So counties in the state of Texas are mandated to provide indigent health care for those who don't qualify for Medicaid. So this is part of the county's indigent health care program. So this isn't a property tax cut for people that we like or what they do. This is part of the program for a county in their indigent health care program.
So the HRO report reads, it would allow a county commissioner's court to exempt the county property taxation up to 50% of an assessed value of a residence for certain licensed physicians.
That's
so
right.
it is a tax exemption for certain licensed physicians.
They have to provide indigent health care for free in order to get the property tax relief from the county commissioner's court.
I'll give you an example of what I'm talking
Sure.
about. There's attorneys that provide indigent legal
That's not
services.
analogous to this.
No, well, it is analogous.
No, it's
because
not.
Well, you're trying to give. So let me ask you a question,
Sure.
Representative. Have you done an analysis of what's going to happen to who's going to make up for this tax? Because if you're lowering
So
the
this
tax
is
value
permissive,
somewhere,
so it's up to the county commissioner's court.
I understand.
So in the state of no, I don't think you do. In the state of Texas, counties can only do what the legislature tells them they can do. So we're giving permission to counties, if they want to, on behalf of their county indigent health care program, to cut the taxes of a physician instead of paying them. So what this does is it actually saves counties a significant amount of money.
So what about the rest of the people where they're not paying taxes, or they're not having to make that up
If they
somehow?
are a physician that participates in the county indigent health care program and agree not to seek other reimbursements, they can't seek Medicaid reimbursements, they can't seek any other federal reimbursement, they can't accept a state reimbursement, then the commissioner's court makes that decision. This is not a thank you. They are literally setting aside hours each week in their practice to provide health care for little children, single moms that don't qualify for Medicaid, but they do qualify in the county health care program.
So in functionality, who's going to monitor this?
It's up to the commissioner's court.
No, well, so there's a
So
doctor.
the people that you elect in your county, your commissioners, your county judge, and your 4 commissioners that you elect, they're the ones that monitor it because it's totally up to them whether they do this or not.
So
that's who monitors it.
If you'll let me finish my question,
Sure.
I would appreciate it, Representative. So you're saying that there's a doctor, and he's going to commit to a certain amount of indigent health care and not seek reimbursement from anybody.
That's right.
So the first question would be, you're saying the commissioner's court's going to monitor him. Who's going to monitor whether he's seeking reimbursement? Is it just the honor method?
No, the Commissioners Court has an indigent health care program, so they don't pay the doctor, and so they're not going to seek that reimbursement. It's all just based on their property taxes.
And how are they supposed to assure that he's committed to certain hours every week and that he's actually doing that?
They negotiate that with the physician, so it's 100% up to the Commissioners Court and the physician. The whole process for reporting hours. This bill is very flexible. It's permissive. So this is entirely up to the Commissioners Court. So how they manage it is totally up to them.
And I can appreciate what you're doing, but what I can tell you is that I can see the potential for extreme abuse here by...
Then take authority away from the Commissioners Court to set the tax rate, because that's what they do every year.
Well, thank you for answering the questions. I think this is a terrible bill.
The chair recognizes Ms. Thompson of Harris in opposition to the bill.
Mr. Speaker and members, I'm not doubting the fact that there are physicians that are needed in the area in which we are talking about to give them a residential homestead exemption. But what about the social worker who gives medical advice and care for those persons? What about the caretakers who help these people? What do we do for them? Are we just thinking about the physician alone? Are we thinking about the persons who are actually providing the kind of medical care and assistance that are needed in this particular area? I think that this is a noble idea, but I just think that the persons who need to be included in here are not included in here, and I would move that we should vote no on this bill and study it and look for another opportunity in which we can include persons, in which we can actually be able to help. What about the caretaker who cleans the poop from our persons who in home care and daycare and senior citizen living facilities? Don't they deserve something? I think that we need to study this. I commend Mr. Shaheen on this idea, but I think that this is an idea that we need to think about. And I think that this is not the approach that we need at this particular time. So I'm asking you to vote no on this bill.
The chair recognizes Mr. Shaheen to close on the bill.
Thank you, Mr. Speaker. Members, this bill, we voted on this last session. It passed the House by over 130 votes and then went over to the Senate where it died. So again, what this is this is totally permissive. It is up to your county commissioners court whether they want to do this or not. This is not a thank you for doing volunteer work, that type of stuff. This is actually a part of your county's indigent health care program. Your county has two options. They can hire doctors to provide care for the needy and pay that physician a lot more, or what this bill does is it leaves it up to your county if instead they just cut the homestead property taxes for that physician of 50%, and that physician cannot seek any reimbursement. So I will tell you, for each of your counties, if they have this option, it saves them a significant amount of money. And for you that are from a large county, I'm talking about saving your county budget millions and millions of dollars. Mr. Speaker, I move passage.
The question occurs on passing the resolution to HB 596. A record vote has been requested from Mr. Tinderhole. The clerk ring the bell. Chairman is Mr. Shaheen voting aye, Ms. Thompson of Harris voting nay, Mr. Meyer voting aye. Have all members voted? So Mr. Bajani voting nay. Have all members voted? Have all members voted? There being 61 ayes and 84 nays, HB 596 fails to pass the engrossment. The question occurs, pardon me, the chair is out on second reading, HB 579. The clerk read the bill.
HB 579 by Burns relating to procedures for the alternative assessment of certain public school students that receive special education services and alternative accountability plans for certain campuses serving students that receive special education services.
The chair recognizes Mr. Burns to explain the bill.
Thank you, Mr. Speaker. Members, we have an opportunity today to pass a bill that we've passed multiple times in this House and send it to the Senate once again because it's the right thing to do. HB 579 empowers parents of students with significant cognitive disabilities to ask for an exemption from the STAR test and the ALT STAR. It directs TEA to create a review involving the parents and the ARD committee. It directs TEA to consult the student's individualized education plan in creating an appropriate assessment for the child. And the bill also allows a specialized support campus, which is a campus with 90% or more of the students there receiving special education services, with significant percentage of those students providing no authentic academic response on the STAR. It provides them the ability to work with TEA to develop an alternative accountability plan. And I believe we have an amendment.
The following amendment, the clerk read the amendment.
Amendment by Gonzalez-El Paso.
The chair recognizes Ms. Gonzalez-El Paso to explain the amendment.
Thank you, Mr. Speaker. Members, this amendment is acceptable to the author, and all it does is help special education students make sure they have their accommodations, and I move passage.
Ms. Gonzalez-El Paso, Senate amendment is acceptable to the author's objection to the adoption of the amendment. The chair hears none. The amendment is adopted. The chair recognizes Mr. Burns to close on the bill.
Thank you very much, members. Move passage.
The question occurs to pass on the motion from HB 579. All in favor say aye. Opposed say nay. The ayes have it. HB 579 is passed on the motion. The chair leads on second reading HB 219. The clerk read the bill.
HB 219 by Noble relating to the release of a deed or trust or other contract lien securing a home loan after payoff by the mortgager.
The chair recognizes Ms. Noble to explain the bill.
Thank you, Mr. Speaker. Members, you might be surprised to learn that currently there is no requirement for Texas law for lender to release a lien on a paid-off mortgage. While attempting to sell their home, some homeowners discovered that the lien on their property was never released, even though they paid off that loan long before. My bill will simply require mortgage holders to release a lien within 60 days of a loan being paid off, or 30 days if the property owner makes the request. This is a best practice bill. We are just putting into law what good lenders are already doing, and I believe there is an amendment.
The following amendment, the clerk read the amendment.
Amendment by Lambert.
The chair recognizes Mr. Lambert to explain the amendment.
Thank you, Mr. Speaker. Members, this amendment simply clarifies that a mortgage servicer is required to comply with this section only if they have the authority to deliver or release a lien for the home loan. I believe this amendment is acceptable to the author. I move passage.
Mr. Lambert sends an amendment. It is acceptable to the author's objection to the adoption amendment. The chair hears none. The amendment is adopted. The chair recognizes Ms. Noble to close on the bill.
Thank you, Mr. Speaker. I move passage.
The question occurs to pass the engrossment of HB 219. All in favor say aye. Opposed say nay. The ayes have it. HB 219 is passed in engrossment. The chair lays out on second reading HB 252. The clerk read the bill.
HB 252 by A. Johnson of Harris relating to the eligibility for an order of non-disclosure of criminal history record information of a criminal defendant who has successfully completed a specialty court program.
The chair recognizes Ms. Johnson of Harris to explain the bill.
Thank you, Mr. Speaker and members. Specialty court programs have been proven to reduce recidivism among participants and improve public safety. Currently, the definition that allows for petitions of non-disclosure are limited to certain courts. What this bill does is expand that definition to, quote, specialty courts, which are all of those that are approved by the governor's office, which will address all of those today and those that the governor's office determines are legitimate for the future. I move passage.
The question occurs on passing the engrossment of HB 252. All in favor say aye. Opposed say nay. The ayes have it. HB 252 is passed in engrossment. The chair lays out on second reading HB 105. The clerk will read the bill.
HB 105 by Noble relating to excluding the furnishing of an academic transcript from the definition of information service for purposes of sales and use taxes.
The chair recognizes Ms. Noble to explain the bill.
Thank you, Mr. Speaker. House Bill 105 passed this body unanimously 2 years ago, but the clock ran out on it in the Senate. Students and graduates from both public and private Texas universities should be treated equally when it comes to paying a sales tax. Members, this bill will ensure that students can obtain their own transcripts without paying a sales tax, regardless of whether that transcript is furnished by a public or private Texas university. I move passage.
The question occurs on passage of immigration HB 105. A record vote has been requested by Mr. Kane. The clerk will ring the bell. Show Ms. Noble voting aye. Ms. Johnson of Harris voting aye. Have all members voted? All members voted. There being 147 ayes and 0 nays, HB 105 is passed in engrossment. The chair lays out on second reading HB 1381. The clerk will read the bill.
HB 1381 by Hernandez relating to the public hearing requirement for a preliminary zoning report made by a zoning commission.
The chair recognizes Mr. Hernandez to explain the bill.
Thank you, Mr. Speaker and members. House Bill 1381 would give municipalities the option to conduct just one public hearing for applications before their zoning commission. I move passage.
Mr. Speaker.
Mr. Patterson, for what purpose?
Will the gentlelady yield for some questions?
Will the gentlelady yield for questions?
I yield for questions.
She yields for questions.
I'm sorry, it was kind of loud in here. Could you just repeat what this bill does?
It's just saying that the zoning commission is only required to have one hearing. Currently, the code says it must conduct hearings, multiple hearings. And for instance, in smaller cities, when things are uncontested, we want things to move and relieve the backlog.
So you're talking about like a planning and zoning commission at the city level?
In their preliminary report, yes.
Okay, and these planning and zoning commissioners, these are appointed by the city councils in most cases, is that correct?
Yes.
Okay, and then you're just trying to streamline things for them to have one hearing instead of multiple hearings, is that what the bill does?
That is correct.
Okay, all right, thank you, ma'am.
Thank you. I move passage.
The question occurs on passage and goes to HB 1381. All in favor say aye. Opposed say nay. The ayes have it. HB 1381 is passed in engrossment. The chair lays out on second reading HB 1433. The clerk will read the bill.
HB 1433 by A. Johnson of Harris relating to the regulation of massage therapy.
The chair recognizes Ms. Johnson of Harris for a motion.
Mr. Speaker, I move to postpone further consideration of House Bill 1433 until 10 a.m. Tuesday, April 25th.
Members heard the motion. Objection. Chair hears none, so ordered. The chair lays out on second reading HB 1429. The clerk will read the bill.
HB 1429 by Campos relating to the definitions of family violence and household member for purposes of crime victims' compensation.
The chair recognizes Ms. Campos to explain the bill.
Thank you, Mr. Speaker. HB 1429 would align the program's definition of family code violence to that approved by the legislator in the Texas Family Code to ensure that all who reside in the household during a violent crime can access the full range of CVC's resources.
Mr. Speaker.
Mr. Patterson, for what purpose?
I'd like to move that my conversation with Representative Hernandez be reduced to writing place in the journal.
Members heard the motion. Objection. Hears none, so ordered.
Mr. Speaker.
Mr. Patterson, for what
Will the
purpose?
gentlelady yield for some questions?
Will the gentlelady yield for questions?
Yes.
She yields for questions.
Ms. Campos, you used, I think, some initials there, but I didn't quite hear them. Could you repeat those initials or abbreviation?
CVC.
Okay, and what does that stand for?
Crime Victims Compensation.
Okay, and that's what this bill does.
It actually includes other family members, individuals that are not family members but live in the household that have had domestic violence.
So if there's a family member residing in the household and that family member would become maybe homeless without these benefits, is that correct?
That is correct. Or if you have individuals that are maybe dating and the girlfriend's getting abused and the children are getting abused, so the funds will, they'll be able to get the compensation as well.
Okay, so it's not just the next of kin, but it's other people that would be affected by the domestic violence. They would be able to be helped by your bill.
Correct.
Okay, sounds like a great bill. Thank you, ma'am.
Thank you. I move passage.
The following amendment, the clerk read the amendment.
Amendment by Tenderholt.
The chair recognizes Mr. Tenderholt to explain the amendment.
Thank you, Mr. Speaker. Members, this just adds 3 sections from Family Code section in that we're missing. I believe it's acceptable to the author. I move adoption.
Mr. Tenderholt sends up an amendment. It is acceptable to the author. The objection to the adoption amendment, chair hears none. The amendment is adopted. The chair recognizes Ms. Compost to close on the bill.
I move passage.
The question occurs on passing the engrossment HB 1429. All in favor say aye. Opposed say nay. The ayes have it. HB 1429 is passed in engrossment. The chair lays out on second reading HB 1106. The clerk read the bill.
HB 1106 by Goodwin relating to the training of and the provision of acupuncture services by an AccuDuct specialist.
The chair recognizes Ms. Goodwin to explain the bill.
Thank you, Mr. Speaker. Members, at a time when many Texans are suffering from stress and anxiety, House Bill 1106 will allow a non-pharmaceutical, inexpensive treatment to be more widely available in Texas. Giving Texans more tools to handle mental health issues is critical. This bill is supported by the Texas chapter of the Military Officers Association of America, and I hope we will pass this bill to allow more Texans to have access to this beneficial treatment. I move passage.
Any members speak for or against on the bill? Seeing none, the question occurs on passage of the engrossment HB 1106. All in favor say aye. Opposed say nay. The ayes have it. HB 1106 passed in engrossment. The chair lays out on second reading HB 3211. The clerk read the bill.
HB 3211 by Stuckey relating to a campus of the Texas State Technical College system located in Denton County.
The chair recognizes Dr. Stuckey to explain the bill.
Thank you, Mr. Speaker and members. This is a good bill to authorize a Texas State Technical College campus in Denton County. We've got good folks back home and even in neighboring Wise County who are interested in seeing this campus open. I move passage.
Any members speak for or against on the bill? Seeing none, the question occurs on passing the engrossment HB 3211. All in favor say aye. Opposed say nay. The ayes have it. HB 3211 is passed in engrossment. The chair lays out on second reading HB 3115. The clerk read the bill.
HB 3115 by Morales of Maverick relating to the eligibility of certain retired or former district court judges for assignment as a visiting judge.
The chair recognizes Mr. Morales of Maverick to explain the bill.
Laid up.
Mr. Speaker.
Ms. Gonzalez, for what purpose?
I move that the remarks between Representative Nieve Criado on her amendment on sexual harassment be reduced to writing and placed in the journal.
Members, you heard the motion on House Bill 2127. Is there objection? The chair hears none, so ordered. The chair will recognize Mr. Morales of Maverick to explain the bill.
Thank you, Mr. Speaker and members. House Bill 3115 is about giving district judges a second chance. A public reprimand is the lowest level of grievance that a judge can receive. And so long as they've behaved and have since not gotten any sort of reprimand in the next 15 years, then they're allowed, whenever they retire, they're allowed to serve as visiting judges. We are not opening the floodgates to this. We've worked very narrowly to construe this bill and make sure that it applies to a certain segment of the population. We have bipartisan support of this bill with Chairman Leach, Vice Chairman Cook, Chairman Cody Harris, and Chairman Terry Canales also supporting this bill. I'd ask that you vote in favor, and I think we need a record vote. Passage.
The question occurs on passing immigration to HB 3115. A record vote has been requested by Mr. Morales of Maverick. The clerk will ring the bell. So Mr. Lozano voting aye. Have all members voted? All members voted. Mr. Jones of Dallas voting aye. There have been 101 ayes and 43 nays. HB 3115 is passed in engrossment. The chair is out on second reading. HB 4015. The clerk will read the bill.
HB 4015 by Thompson of Brazoria relating to the disposition of certain fees collected for the rail safety program.
The chair recognizes Mr. Thompson of Brazoria to explain the bill.
Thank you, Mr. Speaker. Members, House Bill 4015 would require that any fee collected under Transportation Code Section 111.101 would be deposited in the State Highway Fund to be used only for rail safety programs. Move passage.
Any member speak for or against on the bill? Seeing none, the question occurs on passing the engrossment. HB 4015. All in favor say aye. Opposed say nay. The ayes have it. HB 4015 is passed in engrossment. The chair lays out on second reading HB 2183. The clerk will read the bill.
HB 2183 by Stuckey relating to the temporary appointment of county jailers.
The chair recognizes Dr. Stuckey to explain the bill.
Thank you, Mr. Speaker and members. House Bill 2183 is a bill to help our sheriffs ease workforce challenges at county jails. I do have a perfecting amendment.
The following amendment, the clerk will read the amendment.
Amendment by Stuckey.
The chair recognizes Dr. Stuckey to explain the amendment.
Members, this amendment makes two clarifications. The individual who had a jailer's license lapse, they may reapply. Second, if we are closing a potential loophole to make sure we don't allow jailers to be indefinitely under a temporary license. The amendment is acceptable to the author. I move passage.
Dr. Stuckey sent an amendment. It is acceptable to the author. The objection to the adoption amendment. Chair hears none. The amendment is adopted. The chair recognizes Dr. Stuckey to close on the bill.
Thank you, members. Move passage.
The question occurs on passing the engrossment. HB 2183. All in favor say aye. Opposed say nay. The ayes have it. HB 2183 is passed in engrossment. The chair is out on second reading. HB 1142. The clerk will read the bill.
HB 1142 by Theory relating to measures to assist students enrolled at public institutions of higher education who are homeless or who are or were in foster care.
The chair recognizes Ms. Theory to explain the bill.
Thank you, Mr. Speaker. Members, students facing homelessness are 87% less likely to matriculate through college than their peers. House Bill 1142 will assist college-bound students who were formerly in foster care or who are at risk of homelessness by extending on-campus housing resources in between semesters. This bill will help improve enrollment, retention, and graduation rates for our college universities. I would like to thank all the members of this body for providing their input and bipartisan support. I believe we have an amendment.
The following amendment, the clerk will read the amendment.
Amendment by Harrison.
The chair recognizes Mr. Harrison to explain the amendment.
Thank you, Mr. Speaker. Members, this amendment is acceptable to the author. It clarifies the term student in the bill, and it ensures the bill is consistent with existing university housing policies. Move adoption.
Mr. Harrison sends up an amendment. It is acceptable to the author. The objection to the adoption amendment. Chair hears none. The amendment is adopted. Chair recognizes Ms. Theory to close on the bill.
Thank you, Mr. Speaker. I move passage.
The question occurs on passing the engrossment. HB 1142. A record vote has been requested by Ms. Isaac. The clerk will ring the bell. Show Mr. Harrison voting aye. Ms. Theory voting aye. Show Mr. Patterson voting aye. Jones of Dallas voting aye. Show Ms. Cole voting aye. Ms. Hull voting aye. Ms. Swanson voting aye. Have all members voted? There have been 142 ayes and 1 nays. HB 1142 is passed in engrossment. The chair recognizes Mr. Holland for a notice.
Thank you, Mr. Speaker and members. Pursuant to Rule 7, Section 37C, I hereby give notice that I intend in at least 1 hour's time to move to reconsider the vote by which House Bill 596 was defeated and move adoption.
The following bills on first reading or referral, the clerk will read the bills.
HB 5379 by Wilson, relating to the creation of the Williamson and Bell Counties Municipal Utility District Number 1, granting limited power of eminent domain, providing authority to issue bonds, providing authority to impose assessments, fees, and taxes, for the Committee on Land and Resource Management. HB 5380 by Wilson, relating to the creation of the Theon Ranches Municipal Utility District Number 3, granting a limited power of eminent domain, providing authority to issue bonds, providing authority to impose assessments, fees, and taxes, for the Committee on Land and Resource Management. HB 5381 by Wilson, relating to the creation of the Theon Ranches Municipal Utility District Number 4, granting a limited power of eminent domain, providing authority to issue bonds, providing authority to impose assessments, fees, and taxes, for the Committee on Land and Resource Management. HB 5382 by Wilson, relating to the creation of the Jarrell Estates Municipal Utility District Number 1, granting limited power of eminent domain, providing authority to issue bonds, providing authority to impose assessments, fees, and taxes, for the Committee on Land and Resource Management. HB 5383 by Wilson, relating to the creation of the River Ranch Municipal Utility District Number 1, granting limited power of eminent domain, providing authority to issue bonds, providing authority to impose assessments, fees, and taxes, for the Committee on Land and Resource Management. HB 5384 by Oliverson, relating to the creation of the Harris-Waller Counties Municipal Utility District Number 9, granting a limited power of eminent domain, providing authority to issue bonds, providing authority to impose assessments, fees, and taxes, referred to the Committee on Land and Resource Management. HCR 107 by Hunter, granting Aransas County permission to sue Regional Pool Alliance and waiving Regional Pool Alliance's governmental immunity with respect to claims by Aransas County for and in connection with covered losses sustained from Hurricane Harvey, referred to the Committee on Judiciary and Civil Jurisprudence. SB 158 by Perry, relating to the location of a bank eligible to be selected as a depository or sub-depository of county public money, including money held by a county or district clerk, for the Committee on County Affairs. SB 261 by Springer, relating to titling and registration of assembled trailers, for the Committee on Transportation. SB 280 by Zaffarani, relating to the issuance of specialty license places for members of the military who served in Operation Freedom Centennial, referred to the Committee on Defense and Veterans Affairs. SB 322 by Huffman, relating to the compensation of members of the Seawall Commission of the Matagorda County, referred to the Committee on County Affairs. SB 341 by Springer, relating to the applicability of the mixed beverage gross receipts tax and the mixed beverage sales tax to items sold by certain nonprofit entity temporary event permittees, referred to the Committee on Ways and Means. SB 348 by Springer, relating to the prohibition on posting on the internet information held by an appraisal district regarding certain residential property, referred to the Committee on Ways and Means. SB 533 by Paxton, relating to the training for peace officers on responding to and investigating child fatalities, referred to the Committee on Homeland Security and Public Safety. SB 829 by Colcourse, relating to cottage food production operations, referred to the Committee on Public Health. SB 950 by Colcourse, relating to the Attorney General's defense of a district or county attorney against certain lawsuits in federal court, referred to the Committee on State Affairs. SB 1120 by Schwertner, relating to certain prohibited practices by a barber or cosmetologist, referred to the Committee on Licensing and Administrative Procedures. SB 1289 by Perry, relating to the disposal of reclaimed wastewater, referred to the Committee on Environmental Regulation. SB 1427 by Flores, relating to certain criminal conduct and organizations that threaten the security of the state and its residents and borders, increasing criminal penalties, referred to the Committee on State Affairs. SB 1439 by Springer, relating to the ad valorem taxation of tangible personal property held or used for the production of income by related business entities, referred to the Committee on Ways and Means. SB 1663 by Alvarado, relating to the authority of a municipality to alter speed limits, referred to the Committee on Transportation. SB 1741 by Zaffarani, relating to the route designation for the issuance of a permit for the movement of oversized and overweight vehicles in Webb County, referred to the Committee on Transportation. SB 1746 by Perry, relating to an exemption from the requirement to obtain a permit from the Groundwater Conservation District for temporary water wells, referred to the Committee on Natural Resources. SB 1820 by Hall, relating to the prohibited play and facilitation of play of a lottery game by telephone or through the internet, referred to the Committee on Licensing and Administrative Procedures. SB 1835 by Hinojosa, relating to certain contract and notice requirements for the cancellation of a health spa membership, referred to the Committee on Business and Industry. SB 1854 by Paxton, relating to the optional group benefits for dental vision care under the Texas Public School Employees Group Insurance Program, referred to the Committee on Pensions, Investments, and Financial Services. SB 1907 by Betancourt, relating to the preparing and delivering precinct election returns, increasing a criminal penalty, referred to the Committee on Elections. SB 1950 by Betancourt, relating to accepting an early voting ballot voted by mail, creating a criminal offense, referred to the Committee on Elections. SB 2150 by Nichols, relating to the designation of a portion of U.S. Highway 84 in Hoquin as a Lieutenant General O.R. Cottonwood Memorial Highway, referred to the Committee on Defense and Veterans Affairs. SCR 13 by West, recognizing the Texas Black Reconstruction Legislature's Recognition Act, referred to the Committee on Culture, Creation, and Tourism. The following resolutions are being referred to the Committee on Resolutions calendar. HR 1124 by Guerra, HR 1125 by Anchia, HR 1126 by Hinojosa, HR 1127 by Schofield, HR 1128 by Leo Wilson, HR 1129 by Craddock, HR 1132 by Casal, HR 1134 by Button, HR 1135 by Hernandez, HR 1136 by Buckley, HR 1137 by Buckley, HR 1138 by Buckley, HR 1139 by Buckley, HR 1140 by Buckley, HR 1141 by Buckley, HR 1144 by Gonzales El Paso, HR 1145 by Gonzales El Paso, HR 1146 by Wally, HR 1147 by Wally, HR 1148 by Cassell, HR 1149 by Cassell.
Members, the speaker's desk is clear. If you have any announcements, please bring them down front. Seeing none, Mr. Goldman moves the House adjourned until 10 a.m. Wednesday. Is there objection? Chair hears none. The House stands adjourned.